Why does it take African countries years, sometimes decades, to bring back corrupt politicians who run to other countries to evade criminal trial when we in fact know where these politicians are? This is not just bureaucracy. This is a principle in international law called dual criminality. Let me explain. Under international law, sovereign nations have no automatic duty to arrest suspects. Sovereignty simply means that a country's police or the court or the system rules over any other thing within that territory. For extradition to begin, that is the bringing back of a suspect, two nations should enter a bilateral agreement, or there could be a multilateral agreement, which means other nations are involved and they must be signatories to such a treaty. Having a treaty is just one step. The real legal step starts when the question as to dual criminality comes up. The principle of dual criminality comes to be when the question arises as to whether the act or the omission committed at the home country is treated as a crime in the country that is being requested to arrest. A typical example is this. If someone commits an offense in Nigeria and then he runs to Ghana, and Nigeria is requesting Ghana to arrest such a person, the person can only be arrested by the Ghanaian government if Ghana also sees that act or omission as a crime. It is only when such is also a crime in Ghana that Ghana can now proceed to arrest the person. That is dual criminality. Is it also a crime in Ghana as it is in Nigeria? Even if we pass that hurdle, another one is political motivation. If the person to be arrested claims or makes a defense that he is being arrested for political purposes, then the country that is being asked to arrest him will block such an arrest and will not carry it out. This is also where the country that is being requested to arrest feels that there will be torture or unfair justice if he is being extradited to the home country. This is why we see that most corrupt politicians who evade prosecution and run to other countries are not being brought back home to face such trials. This is as a result of the delicate nature of this principle in international law called dual criminality. Now, do you think that this dual criminality is a principle of law that should continue, or are politicians now using this as a loophole to evade prosecution, particularly when they cite political motivation or unfair justice or torture? Let me hear your thoughts.